Hello, I'm Shalini Bhargava Ray. I'm a law professor in the United States. I teach at the University of Alabama School of Law, and in recent years, I've written about the criminalization of humanitarian aid to unauthorized migrants, many of whom are asylum seekers. So the principal setting for my work is the U.S.-Mexico border, and it's a dangerous and deadly region. The climate is harsh with massive fluctuations in the daily temperature from morning to night. And those dangers are compounded by policy choices of the government. And so starting in the mid-1990s, the government made an effort to close off the more direct routes into the United States in an effort to deter migrants from undertaking the journey. And this is probably a familiar story, sort of worldwide, where haven states attempt to deter migration, and what ends up happening is migrants make the journey anyway, but face a great deal more danger in doing so. And so starting in the late 1990s, statistics indicate that the toll has been pretty serious. Hundreds of migrants have died every year in this area after the promulgation of these deterrence policies. And the response from civil society has been really robust I think, in a lot of ways. For years now, there have been NGOs in the border region that have provided water and in some instances food or medical care to migrants who are making the journey from Mexico to the United States. Some of these organizations, I think, see their mission narrowly as saving human lives, and others have a much broader kind of political critique of the immigration system and government policies that sort of lead to the kind of need for migrant rescue in the first place. And so I think there's a real range in the NGO sector in the United States. And in recent years, what we've seen is that the government is willing and able to prosecute humanitarian actors or good Samaritans who provide aid and engage in migrant rescue. And there was a very high profile case in the United States involving an activist with No More Deaths, an organization based in Arizona. And he was charged with some misdemeanors for placing jugs of water in the desert. And then he was also charged with a felony for assisting migrants. And I'll talk a little bit about what law was used to prosecute him in a moment. The picture here is from Europe, and it shows kind of the transnational nature of this problem. The criminalization of humanitarian aid, of course, is not unique to the United States. Civil society actors in the EU and Canada and other jurisdictions face these same dangers of being prosecuted for their work. The linchpin of the US criminalization scheme is this harboring statute. It's available at Title 8, Section 1324 of the US Code, and it prohibits smuggling, transport, harboring, or inducing to remain any unauthorized non-citizen. Alien is the term used by Congress. And I'm particularly interested in this third section here, which prohibits concealing, harboring, or shielding from detection an unauthorized alien. And Congress didn't define harbor, and so federal courts have actually interpreted it in very different ways. Some interpret it narrowly as meaning something like hiding someone from law enforcement. Others interpret it much broadly to mean substantially facilitate the person's presence. And so I think that latter broader interpretation is a source of real danger for humanitarian actors. They're very vulnerable when harboring is interpreted so expansively that it might cover things like the provision of food and water. And so in my work in recent years, I've thought a lot about tools available to civil society actors. Given these laws criminalizing humanitarian aid, what are some tools that are available to civil society actors to resist criminalization? And I talk about a number of these in my work. I'm going to highlight a couple of unique ones. So I think in the United States, we have a statute called the Religious Freedom Restoration Act, which we call RFRA, and very broad protection for religious expression. And it's been used by humanitarian actors, including in that very high profile case involving the No More Deaths volunteer that I mentioned earlier. He asserted a RFRA defense, and that was successful with respect to the lesser criminal charges of littering and so on. It was not successful with respect to the felony harboring charge. And so this is an evolving area of law that I think is important to watch. I'm also very interested in the potential for administrative licensing. So the notion that humanitarian aid might in some sense be illegal or criminalized, but there could be a space that the government carves out for select organizations to do good work. And I think European scholars are rightfully, have rightfully been very critical of, this type of regime, which I think is very similar to the codes of conduct that we see in EU nations. And so I offer it with a caveat that I understand it's potentially problematic, but I think it's worth talking about potential licensing regime. And then I go into greater depth, of all four of these in my written work, which I will, I'll share the details of how to find it. I think it's really important for scholars, especially those of us in the US, to really think more broadly about what's happening across the world. And I found it very useful to look at international legal instruments that regulate migrant smuggling and rescue, and the laws in the EU and Canada, where, which I think, especially in Canada, I think it's evolved in recent years so that purely humanitarian assistance to migrants is not criminalized anymore. But the EU, I think, it's still a problem that humanitarian actors face. And so I'm going to close with a discussion of brief description of some of my recent work. So in 2014, I published an article called Optimal Asylum, where I argue for what I call an asylum visa and what other scholars have called protected entry procedures. I look at their history, the logic behind it, sort of why they went away and why we should bring them back. In Saving Lives, published in 2017, I do a comparative law analysis of criminal laws prohibiting humanitarian aid to unauthorized migrants. And in The Law of Rescue, which was just published this past summer in 2020, I try to sort of step back and theorize the prohibitions on migrant rescue and understand sort of hidden logic behind those laws. And I do so by examining rescue sort of with a broader lens, looking at torts, maritime law, criminal law more broadly, and sort of understanding how do different legal regimes regulate acts of rescue and why. And so I've left my citations here, and I think almost all of these articles are available on the web. And I appreciate your time, and I hope that you find my work interesting and potentially useful as well.